Chen Chakravarti, Mr. Devdas Lata, and Vishal Shah.
Latest trends in patents and other intellectual property rights. So let me introduce to our speaker number one, who is speaker will be Mr. Sanjeev Kumar Mahato. He is the examiner of patents and design, Group A Gazetted Officer, the Patent Office Kolkata, from the Department for the Promotion of Industry and Internal Trade, Ministry of Commerce Industry, Government of India. So now I'll hand over this session to Mr. Braj Mohan Singh. Braj sir will take us forward through this course. Thank you.
Okay. Thank you, Mr. Satyanand Vishwarma, and thank you, Pankaj sir, also. So myself, Rizmohan Singh. So I'll take the part one of this presentation, right? And I'll cover the basic concepts of IPR actually. And the second part will be taken up by my fellow speaker, Mr. Sanjeev Kumar Nair. So let's move to part one of this presentation. See, first of all, we will go through the background of the intellectual property. What is actually the intellectual property? Let's check what is a property. If you go to the language of law, in that the property is defined in many different ways as per the needs and uses. But in general ways, the property is any physical or virtual entity that is owned by a person or a group of persons, like house, car, and like that. Then what is a intellectual property? Intellectual property is actually a virtual entity or virtual property, or you can say it is a non-tangible property that is a creation of mind, right? So intellectual property is a property that is a creation of mind, and like inventions, literary and artistic works, designs, symbol, names, and trademark, like that. So after that, moving to next slide. Okay. So let's move into what is intellectual property right. So we have seen what is intellectual property, but after that, let's move to intellectual property right. It is actually a legal right to protect your intellectual property. So if you have any intellectual property, you should get that protected under a legal right, that is IPR. So here in the slide, you can see that for different intellectual properties, we have different IPRs. Like patent is for inventions, and copyright is for protecting literary and artistic works. Industrial design, this IPR is for protecting designs. Trademark, it is for protecting symbols, names and images that are used in the commerce. Then GI, that is geographical indications. Then SICLD, right? So we have a overview of intellectual property right. Then moving to next slide, what is the importance of intellectual property right? That means why we should have intellectual property right. So we have three advantages. Number one is that we will get a protection of intellectual property. That means your intellectual property that will be protected if you have IPR against your intellectual property. Second advantage is this IPR will exclude others from making, using, selling, or importing the patented product or process. And third is commercialization. That means the owner of the intellectual property can commercialize and earn from there, right? So now we have 6 main intellectual property rights, as we have discussed before also. So we will discuss one by one all the IPRs. So in the next slide, we can see that how a single product can have different IPs. Like you can see in the slide that Apple laptop is showing around 5 IPRs, like LED display that is protected under patent, and the body of the laptop that can be protected under the IPR design, and Apple sign that you can see that can be protected under trademark. Then user manual, that user manual of this Apple laptop will be protected under copyright. And then last one is layout of IC, that is under SICLD. So here you can see that a single product can have different number of IPs. So now we will discuss patents. What is a patent? Patent is actually a statutory right. That means it is the legal right for an invention granted for a limited period of time to the patentee. That means the owner of the patent, owner of that invention, that is granted a statutory right in exchange of full disclosure of his invention. That means after the period of 20 years, that is the period of his patent. After that, the full disclosure of the invention will be taken, and it also excludes others from making, using, and selling, importing the patented product or process. And you can see that there is no concept of global patent here. And the tenure of the patent is 20 years from the date of filing of the application. Right? So in the next slide, you can see that the first patent was granted in India in 1856. That was given to George Alfred Depenny, who was the civil engineer of Calcutta, and that was for his invention, an efficient puncture pulling machine. And further, you can see that different scientists and his important inventions. Right? Next, moving to design. So this IPR is actually, this design means only the feature of the shape, configuration, pattern, ornament, or composition of lines or colors applied to any article, whether in 2-dimension or 3-dimension, or in the both forms, by any industrial process or means. Right? And what it doesn't include, these are any mode or principle of construction or anything which is in the substance or a mere mechanical device. Right? And the tenure for the design is 10 years, and it can be further extendable to 15 years. Right? Moving to next slide. Here you can see different design, like a design of a sari, design of a fan. Right? So it's a physical perception of that device. Right? You can see here it is watch, a design, different design of a shoe, and different designs of bags. Right? Here you can see different shapes and configuration of the bottles and cups. So all these things comes under design. Moving to next slide, it is trademarks. So what is a trademark? Trademark is any word, name, symbol, or device, or any combination of these things. And it identifies and distinguishes the goods and services of one company from other companies. And what are the importances of this trademark? It provides exclusive monopoly over a class of goods or services. And the second importance is it allows business entity to build public goodwill, right? And brand also. Third point is it identifies the origin of goods and services, and it also assures a good quality of service and goods. Right? So next, moving to subject matter of the trademarks, that is how many things can be can come under trademarks. Like a name can also be used as a trademark. Collective marks can also be used as a trademark. Certification marks can also be used as a trademark. A tagline, a slogan, that can also be used as a tagline as a trademark. Shapes, different shapes, that also comes under this trademark. And sound marks also. This also can be done under the trademarks. Right? So next, moving to next slide. Here you can see a good trademark. What qualities that good trademark should have? The most and the important quality of a trademark is, of a good trademark, is that it should have a distinctiveness property. That means it should be inherent and it should be acquired. It should not be deceptively similar, right? As you have seen many different trademarks, false trademarks, which are deceptively similar to the original ones. right? So before adopting a new mark, it is advisable to have a search conducted and evaluated. Then only you start your new mark. So how to indicate your trademark? If your application is pending or unregistered, then the symbol T and M will be used as your trademark. And if your trademark is registered, then symbol R within a circle that will be used. Right? So moving to next, copyrights. Copyrights, it's actually a right given by the law to the creators of literary, dramatic, musical, and artistic works, right? And the producers of cinematography, film, and sound recordings. So anything that is created through literary, dramatic, musical, and artistic works, that will come under copyright. And it is a bundle of rights, right? Like right of introduction, reproduction, communication to the public, adaptation, and the translation of the work, right? So copyright doesn't ordinarily protect titles, right? So titles can't be copyrighted. Slogans, short phrases, methods of plots or factual information that cannot be copyrighted. And the tenure of the copyright is 60 years. For different type of literary work, it is different. So in the next slide, we'll see that. Okay. So here you can see that what criteria for the work to be copyrighted. That means what is the minimum criteria that any work can be copyrighted. Number one is fixation. That means that copyright should be fixed with some tangible item. That means with some paper or anywhere, something tangible item that should be fixed with some tangible item. Second point is originality. That means that work should be original. And third is creativity. That means that work should have at least minimum creativity. Beyond that, that means without that creativity, that work cannot be copyrighted. Right? So there are three minimum qualities any work should have for getting copyright. So here you can see that different time spans for different type of copyright works, like for cinematography, film, and sound recording. The time of that tenure of that life is 60 years from the date of publication, and for broadcast reproduction, it is 25 years from the year of broadcast. And performance right, it is 50 years from the year following the year in which the performance is made. Right. So next IPR is SICLD, that is semiconductor IC layout design. So as I think most of the students, engineering students, know what is IC, semiconductor IC. So this semiconductor IC is nothing but the interconnection of various electronic components with at least one active element integrated in or on the semiconductor substrate to perform an electronic function. Next thing is what is layout design. Layout design means it's a 3D disposition of circuitry elements, including the LED wires connecting such elements in a specific manner in SIC, that is semiconductor integrated circuit. And this office for SICLD, it is IPO Delhi, and SICLD, it is an important idea for the protection of products with fast shifting technologies. That is all type of integrated circuits which are novel and innovative, that will be that will be protected under SICLD. And the protection, that means tenure for this SICLD is 10 years, which starts from the date of application, filing, or first commercial exploitation, whichever is earlier. Next IPR is GI. That is geographical indication. So GI is an indication that identifies a product that have some geographical origin or possess some qualities related to that geographical position. So if a product has some geographical qualities related to some geographical position, that can be protected under GI. Like you can see in the slide, like Darjeeling tea, Makrana, marble, Ratlam is saved, Antipiram cell, right? Similarly, you can see different GI tags, and here we can see different terms or validity of our various IPRs. Like for patent, the tenure for patent is 20 years. For designs, it is 10 years plus extendable up to 5 years also. Trademarks, it is initially for 10 years and further it can be renewed. GI, it is initially for 10 years and it can be renewed also. Copyright, it is 60 years plus life and depends on the type of work also. So all IP rights are territorial in nature. That is well known to all of us. So this is the end of the part one. So I just want to hand over to the second part to this to my fellow speaker, Mr. Sanjeev Kumar Mehto. Sir, please. Thank you, Parit Mohan. Now, we will conclude with the part 2 of the webinar, which will here we will understand how understand the patent application, what we look in a patent application. Second point is the difference between a patent literature and a non-patent literature. Third point, what are the requisites for filing a patent? Fourth is the how a patent is drafted, what is the fee schedule, and what is the filing procedure. Now, in the sixth point, we will understand how to search a publication, either patent literature or non-patent literature. In the seventh point, we will do a case study. And seventh is how a research scholars can manage the disclosures to any person outside. And none is the latest trends in patents and other IPR. Now, understanding a patent application is the most tedious task. What we look in a patent application? First thing, what is the problem statement being discussed? What is the problem is faced by any person who want to make a patent? Second is what is the solution already available? If you do a prior art search and you will understand the solution is already existed, then that cannot be patented. You have to see the drawbacks of the previous solution. What are the drawbacks are there? What solution we are providing to the new solution? And new solution is being proposed. That is the patented in part. Now, in this slide, we will understand what is the difference between patent publication and a non-patent publication. First of thing, we will see the content of the patent application. The content is the technical solution to any problem. But in a non-patent literature like journals and transactions, they are mainly publishing the basic research findings. There is no particular solution to a problem. How we can access a patent publication? There are databases which are available worldwide: Google Patents, IPO, Indian Patent Office, European Patent Office, US Patent Office are there, where you can search your patent database. And non-patent literature can be searched on an open access and paid access journals. Third point is the plagiarism check. In patent, we do not search for plagiarism. We do not check it plagiarism. But in non-patent literature, we search for plagiarism. What is the how quality can be assessed? In patent publication, only examination. After that, you will get the report. The quality of your patent application is judged. But in non-patent literature, there is a peer review. Your paper is reviewed by other researchers. Then you will get the quality, that how much your patent publication is will have a quality. In the subject category, the patent publication is based on technology field. For each technology, there is a technology classification. But in non-patent literature, there is subject field. Suppose there is machine learning or artificial intelligence, there is a literature a journal where they are publishing any publication on artificial intelligence or machine learning. But in patent, in machine learning also, there are various classifications that machine learning is applied to which kind of invention they are applying it to it. Now, what is the reason to publish the patent literature? Mainly, the reason is economic gain. Commercial monopoly or licensing is the main activity. But in non-patent literature, only scientific revision is mainly focused. Who are publishing the patent literatures? Patent literatures are mainly published by the companies or research entities who are entirely working on a technology field. They are giving, just like CSIR, they are they're providing a solution to a problem. But in non-patent literature, mainly are done by academic institutes like universities, colleges, and researchers. They are doing the non-patent literature. So, what is the cost incurred? Patent is a costly publication. You are required to pay the fee. But in non-patent literature, there are fee-based also or free also. What is publication time? In patent literature, it will be only published after 18 months, except in the case of an expedited publication, that it will be published instantly. But any publication that is ordinary, that will be published after the 18 months from the date of filing. But in patent literature, non-patent literature, it will depend on the review process. How much time the reviewer is taking, then it will be published. Moving on the next slide, we'll see what are the documents required for a patent application in India. For filing a patent application, you need a set of forms that is prescribed in the Patent Act and patent rules. The first one is the patent form 1. That is actually a form 1 is a job application, like a job application. You are giving the basic details of your invention, name, applicant's name, inventor's name, and address. Everything you are providing in the form 1. Form 2 is a complete specification that you are disclosing the inventions. Your disclosure of invention is given in the form 2. Form 3 is the declaration of undertaking of foreign patent filing. If you have filed any foreign application, then you will disclose in Form 3. Form 3 is the declaration of inventorship that is given by the applicant that you are in the possession of the invention. Form 9 is for only expedited publication if a publication is expedite only. That is a different case we will take over in the next slide. Form 18 is the request for examination. If you are not filing the Form 18, the patent application is not examined. Only after 18 months of filing, your patent application will be published only. It will not be examined if you are not filed in 48 months. After that, the expiry of 48 months, your application will be abandoned. The Form 18A is for expedited examination. That we will see later on. Form 26 is power of authority. If you are filing through a patent agent, then you have to require to file a Form 26, that is power of attorney. And last one is the priority document. If you are taking any priority from any application outside India, then you have to give the priority document. For ordinary applications, no priority document is required. Moving on the next slide, we'll see what is the part of the Form 2. Form 2 is the complete specification that you see in the journals of papers you published. That is just like a paper, that thing only. That will include the first part will be including abstract. You will disclose the brief summary of your invention. Second is the description. That will disclose the field of invention and the background. What are the prior arts? What are the background? Any inventions? What I have done? What is the problem you faced in the previous prior arts? That you will disclose in the description. Summary of invention is the basic summary. What your solution you are providing, you will provide in the summary of invention. Fourth one is the brief description of the drawings. We will give the description of the drawings, what drawings you are filed, and you will give the form figure 1, what figure 1 is disclosing, what figure 2 is disclosing, and any number of figures you have to disclose the title of that figure. Fifth one is the detailed description of the preferred embodiment. In this section, you will disclose every part of your invention with figures. You have to put the figure numerals in the description, and you have to disclose each and every part of the invention, that what inventions, how you are performing your invention. The last part is an important part is the claims. Claims is only that is the patented thing. What you are disclosing in description cannot be patented, but what you are claiming, that can be only patented. But what you are not claiming is cannot be patented. That is the unclaimed. Claims can be any device claim or apparatus claim, system claim, method claim, or process claim. What your invention is providing solution, that will depend on that. And the type, depending on the type, claims can be of independent type or dependent type. Any independent claim, that is a stand by themselves. They disclose the basic important features of your invention. In the dependent claims, you will further give the embodiments of what features are assisting the independent claim, that you will disclose in the dependent claims. Moving to the next slide, you'll see a provisional specification. This is the most important for the researchers. This this is filed if the applicant feels that his invention is in early stage and cannot be disclosed in a publication. To protect his invention, he will first file the provisional application and he will be given 12 months time to file the complete specification. Within 12 months, he has to file the complete specification. After filing the patent application, he can publish any document. His patent application will be protected through the provisional application only. If his suppose his application research cannot be done in 12 months, he is requiring a much more time than that. Then Patent Act allows a post dating of application for maximum of 6 months. That can be only maximum of 6 months. You can post date 1 month also, 2 months also, depending your how much time you are taking for your invention. Other purpose is that it secures priority date of application. If you file the provisional application, it will secure a priority date, and before after that any application, your protection will be saved. It provides security and form of interim protection to the applicant until he pursues the complete patent. This is just like a learner license. You get a learner license, after that 6 months you will get a driver license. Within the learner license you will not be get challan. You are getting protection from the getting challan. And this one is the expedite application. This is the new thing it is given. Expedite application is for startup companies, a small entity, or applicant is a female or one applicant. Any one applicant shall be female, or the government of India or other government residents like ISM Dhanbad can file a expedite application also. If India is chosen as a ISA or IPEA in the PCT application, or any agreement between Indian Patent Office and a foreign patent office, just like in India and Japan, we are having a collaboration with the Japan Patent Office and we are doing a patent highway examination. Just like if ISM is a government organization, he can file a government at ISM can file a application with expedite examination. Or if it is a ISM is not filing any other company or organization filing, if the inventor or applicant is a female inventor, then he can file a expedite examination also. What are the fees required for filing a patent office? Filing a patent in Indian Patent Office. Here we can see the different fees for the forms. Form 1 is required 1600 for a natural person or a startup or small entity or education institute. Just like IIT the Form 1 fee will be only 1600. Earlier it was 8000 rupees. Form 2 is no fees required for Form 2 up to 30 pages and 10 claims. If you exceed more than 30 pages and more than 10 claims, for each claim and each page you have to give the price fee. Form 18, that is the examination fee, it's 4,000. The total, if you see, 5,600. That is the minimum fee required for filing a patent in patent office by a government organization or a natural person, a small entity. If other than natural person is filing a patent application, that Form 1 will require 8,000 rupees and examination fee is 20,000. 28,000 is required for other persons. For natural persons, startup, small entity, education institutes, will require minimum of 5,600 only. If you want to more see the fee details, you can refer the first schedule of the patent rules. You will get the fee schedules of all the forms. See, now we will see how to file a patent application. There are two processes to file a patent application in India. One is the offline filing and second is the offline filing. In online filing, you have to submit the hard copy to the patent office. And in offline filing. In online filing, you can file through the module that is given in the link is given in the screen. But in the online filing, you will require a digital signature key of class 2 or class 3 minimum. Then you can only file. Offline filing is not for patent agents. Patent agents cannot file offline filing, but any other person can file online filing also, offline filing also. So we will see the flowchart of the patent. How, if you are filing a patent, and what is the process of what your application go through, how many stages. First is the patent filing. You first file your patent application in Indian Patent Office. After that 18 months of the publication, after that 18 months, it will be published in the patent journal. If it is not, if star mark is there, that is its exception is the expedite application. After 18 months, it will be published. After that, you have filed Form 18, then request for examination is filed within 48 months from the date of filing. That is 4 years is given to file for request for examination. If you are not filing for Form 18, then your patent will be application will be rejected, abandoned at this stage only. If you are filing the request for examination, then it will be examined, and first set of objections will be raised in the first examination report, APR, that is given by the patent office to the applicant. After 6 months of the APR, applicant has to give the reply. If it is beyond 6 months, it can be extended up to maximum of 3 months with a fee. But generally, many people reply within the 6 months. The FA response is filed with the applicant. If the patent office examiner or controller is not satisfied with the reply of applicant, then a second objection is raised, and that is given. A second examination report is given to the applicant. If after that also, if the office is not satisfied with the reply, then hearing will be conducted. Or at this stage, if all objections are met, then patent will be granted or refused, depend on the objections raised. Final decision is taken, patent or granted or refusal after hearing. There cannot be a hearing is not always, but if objections are not met, then hearing will be conducted. Now we will see what is the meaning of patent search. A patent search is a prudent and cost-effective process of searching all published documents all over the world related to your invention or research. Based on such results, you can determine whether your invention is patentable or up to what degree your invention is patentable. A search may help inventors to modify their efforts. If you have searched some documents and you're thinking that your invention is not patentable, but you will understand up to how much degree it is a patentable and what modifications you can make your invention to make it a patentable invention. See, till now, many research scholars and universities are searching. That's like typing the Google, searching for the keywords only, or title they are searching in the journals or publications. See, how much relevant documents you get after searching on Google only. Google searches with the AND operation. What you are searching, what your keywords you are putting in the Google, that will search with the AND operation. That will apply Boolean algebra, Boolean algorithm, and all the keywords, and that will search. That will give all the documents. Google will find with the same keywords anywhere in the document, but will not give the precise publication. Now in this next slide we will see how can be the patent search strategies. There are mainly 4 strategies, but for the research academic persons, only first keywords and Boolean logic is important for you. We will see in the next slides how we will search using keywords and Boolean logic. First, keywords and classification. Classification is used in patent only. It is not used in non-patent literatures. So classification, metadata is inventors, assignee, name, date. You can search by name also. How much ISM Dhanbad has filed, pin number of applications. You can search by using metadata. Or you know the patent application number, you can search by patent application number also. Where to search for publications and patents? First one is the IPO INPAS. IPO INPAS is the search engine by the Indian Patent Office. You can see in the IPO India website also. Second is the Google Patents. That is a free. Google Patents is a free database. You will not be charged there also. WIPO, USPTO, and EPO. WIPO is the World Intellectual Property Organization that is given. It is also a free search engine. USPTO is also free search engine. EPO, SpaceNet is also free search engine. But in the USPTO and EPO, you will get the maximum of your EP documents or US documents only. But in Google Patents, you will get all the patents of publications all over the world. See, here is a snapshot of a Google Patents web. When you open the googlepatents.com, you will see this type of screen. Here you see the search terms. Here we are keeping some search terms. It will include patent literature also and non-patent literature also. EP and USPTO in past will only give patent literatures, but Google Patents will give you patent literature as well as non-patent literature. You can customize your search text with publication, priority date, or filing date you can change, and you will get the result. Here I have searched the PID controller or PID regulator. See, this number of results I am getting. We will understand why you are writing near 3 here. We will understand the next slides. Now, this is a syntax for search. First is the exact word. What if you have written sanitizer, sanitizer dispenser in the column? If you are writing the same sanitizer dispenser, the Google package will search all the documents where sanitizer and dispenser are displayed by only one word. Exactly same word it will search where it is available. Second is the Boolean logic. Boolean logic and or not we are using. If you are searching sanitizer and dispenser, it will search for both number separated by any number of words. It will not see how much it is separated by how much number of words. Just like you are searching title of any invention or publication in the Google patents, that is done by AND operation. That is AND operation is used there. And second one is the OR operation. If you are searching sanitizer or disinfectant, it will sanitizer and disinfectant are both synonyms, can be similar to each other. So if any sanitizer is searched or disinfectant is searched by OR operation, it will search all the papers where sanitizer or disinfectant is available. Any of these can be available. Third one is the NOT operation. If you are searching with sanitizer, not dispenser, it will search sanitizer, but it will not search dispenser. Any publication where sanitizer is there but dispenser is not there, it will show the documents. But in the earlier sanitizer and dispenser, it will show all the publications with sanitizer and dispenser. Here it will not show any dispenser word in the publication. What is proximity sensor? Proximity logic. Here we are searching with sorting the Boolean logic to a minimum number of words. If you want to search a sanitizer dispenser separated by only 3 words, then we will write sanitizer near 3 dispenser. It will search all the publications where sanitizer dispensers are separated by 3 words. In any order, in a backward order also, in forward order also, it will search all the orders. Second one is the adjacent. We can say adjacent. Sanitizer ADJ 3 dispenser, it will search sanitizer and dispenser, but in the same order. Sanitizer will be first. After the 3 words of the sanitizer, only dispenser will be searched. But in the near 3, it will dispenser and sanitizer will be searched in any direction. Last one is the wildcards. Wildcard something you don't know about that word, then you can use the wildcards. So the question mark is there, that will search for 0 character or 1 character. Just like sanitize question mark. Sanitize question mark. The question mark is only 1 character will be there or 0 character will be there. Then what if you search for sanitize and question mark? It will search sanitize, sanitizer, sanitized. Only these words can be searched by question mark because only 1 character is there. Any character more than 0, it will be searched. Sanities, it will search sanitizer, or sanitized, or sanitizing, sanitization. Any number of words that you can see, 2 words, 3 words, 4 words are searched. In the fourth one, $X number of characters. If sanity is $3, it will search between 0 to 3 characters only. Sanitizer, 2 words are there, sanitize, 2 words are there, sanitizing, 3 words are there. But in sanitization, there are 5 words. But sanitization will be not searched if you are searching with sanitize $3. In the last one is a hash. If you are using hash, exactly 1 character will be searched. In many places you will see sanitizer S is there, or in many places it is Z is there. If you use sanities $ER, then it will search sanitizer with S and sanitizer with Z. Both it will be searched. Or if you are using sanities S, then it will search for any exactly 1 character after that S. That is sanitize. sanitizer will be there, but sanitizer will not be there because it is searching only one character. In the last, if you are using sanity hash and doll star, then it will be search for any number of words with after that hash. The scientist hash will search sanitize. After that sanitize any number of words will be there. It's just a sanitizer, sanitization will be there. Let's say you see the case study. This is a non-patent literature, general algorithm tuned PID controller for process control. So what the keywords will be there in this publication? PID controller or PID regulator will be there. If you can tune the PID controller also, genetic algorithm is there, process control is used, and something that using genetic algorithm, the process will be optimized. We will see how we are searching this paper and get the relevant document. See, here some such strategies are given here. So here we are using PID near 3 controller. That will be searched. That will search PID with controller with 3 number of words. And genetic algorithm in the semicolon will search genetic algorithm exactly the same word. And process near 3 control, it will search process and control with separated by only 3 words. In the next such strategy, we are searching PID near 3 controller or regulator. That is the user bracket. We are searching PID near 3 controller and PID near 3 regulator both. PID controller regulator are both similar terms. Any application there can be written a PID controller or PID regulator. So we are searching PID near 3 controller or regulator. In genetic algorithm, the same we are using, and process control we are using same. The next such we are using PID near 3 controller, and you're tuning the PID controller, and I'm searching any word tuning is there after controller with separated by 5 words. Maximum of 5 words will be there. Genetic algorithm is previously same. Process near 3 is there. In the fourth one, PID near 3 controller regulator near 5 tune star. Tune star mark is the tune, tuner, tuning, tuned. Everything will be searched by this strip mark. In the second last, PID near 3 controller or regulator near 5 tuning. That will we are changing our search strategy. Now earlier we are using genetic algorithm. Now we are using a particle swarm optimization. If some paper is published on a particle swarm optimization or not. Earlier publication was in genetic algorithm, but we are now searching for particle swarm optimization. We are searching particle near 3 swarm. Any publication having particle near 3 swarm, PID near 3 controller or regulator, or near 3 tuning or PSO, that will be shown. The second last, PID near 3 controller or regulator near 5 tuning, that is previously, and particle near 3 swarm or PSO, that will be disclosed. In the last one, we are searching PID near 3 controller regulator near 5 tuning. It will search PID controller tuning with 5 words and 3 words separated by 3 words or 5 words. Particle swarm automation will be searched, or PSO it will be searched. Any of both will be there. And publication, I am searching any document before 1st January 2021. Before publication, it will show all the documents which are published before this date. As per the requirement, you can change. Now, what is the research practices to manage disclosures? How you can manage your patent disclosures? First, in the provisional description, we have said that first file your patent, then publish it. That is the best way to protect your invention. Second one is the don't reveal enabling details. Just like in abstract publications or poster competitions, you are disclosing your inventions in the poster publication. That can be utilized by any other person, and patent will be filed, and your protection cannot be secured. Third, do use confidentiality agreement with dealing with the outsiders. If you're any agreement with the other persons, then mark it confidential in your agreement. Fourth one is the mark critical enabling details in grant applications. If you're writing any project work or grant applications, must mark it confidential in the application. Now this can help you in managing your disclosures of patent application, and will secure your invention also. Now we will see what is the India scenario in the Global Innovation Index. the last 6 years, in 2015, India ranked 81st in the Global Investment Index, but in 2021, India is reached to a rank of 46th in the global. But in the terms of patent filing, India ranked around 7th worldwide. See here, see state-wise patent filing. The Maharashtra is the only state with maximum number of patent filings after the Tamil Nadu, Karnataka, and southern states are filing much number of patents compared to the northern states. We will see the northern states will be also filing patents. The top Indian applicants for patent from academics, the universities, IITs collectively, IIT is filing the maximum number of applications. Second is Lovely Professional University, Chandigarh University, Bharat Institute of Higher Education, Chandigarh Group of Colleges, MIT, Sanskriti University, and many others are there. In the foreign resident applications, those who are foreign companies but are resident in India, just like Huawei Technologies, they are filing patent applications. Qualcomm, Samsung, Guangdong, Oppo phones, Ericsson, they are filing. Microsoft are filing. Philips are filing. Now we'll see on such here. If you search this term here in Google Patents, you will see this includes patent literatures. This is not patent literatures. If blue mark is there only, then it will show only patent literatures only. If it is the gray mark, then it will not show any non-patent literature. And if you have marked both of blue is there, then it will search all patent literatures as well as non-patent literature. And if you remove the patent literature, you will get the only non-patent literatures will be there. So we are searching for a PID controller or regulator tuned by 5 words, particles on optimization, and PSO is there. After searching this by this, you will get the best results for what you are searching for your application or citation. Search terms are there. If you want to add something here, like I have written genetic near-3 algorithm star. If you search by this, it will search all these terms also and this one also. Search will depend on your strategy and what keywords you are searching. What your motive behind the search. Now this is the last slide. Any questions you can ask? We are happy to answer. Okay, this one.
Hello.
Hello.
Yes, sir. I would like to ask one question.
Yeah.
So I want to ask that if we have filed a invention for a patent, okay, and it is taking time. So while that time, can we send it for a journal?
Yeah. After filing patent application,
And
you can
then
publish anywhere. After filing a patent application, you can publish anywhere. That will be protected by the patent office. In fact, if your publication is there, you have published earlier also, then you can after you published one journal publication you have published, and after that you have filed a
yes, sir.
application, then your patent publication cannot be anticipation, because in Patent Act one provision is there that if the same publication of yours. If that application is journal of yours, then it will be not anticipated. But you can, after filing of patent application, you can publish anywhere. That is not a problem.
Means it is advised basically that you first publish a paper and first apply for a patent and then go on and publish the paper. But even if you have published a paper previously, then the Patent Act allows the people to file for a patent application during a term of 1 year after first publication of that material elsewhere. So if you have published a paper today, 1st of April 2022, so you can file a patent application for the same paper before lapse of 1 year of that this term. That is up to 1st of April 2023. So in any case, if you have filed for the patent application and it is in process, so you can apply. Now it is protected by the patent office. You can now disclose it to anywhere you want.
Good afternoon, sir. I have one queries regarding a computer program. So is it patentable or it is copyrighted issues? And
actually,
the publication. Can I go for publication for first, then go for that copyright or patent? Or first have to apply for copyright or patent or then publication?
Yeah, actually, computer programs per se, there are certain things. They can be inventions. For example, computer program. First check for a computer program is whether it's an IP. Yes, it's an IP because it is applied. It is made by the application of mind. Then what kind of IPR will protect it? Whether it will be patent or copyright. The second question is this. Now, according to patent text, in section 3K, it is written that computer program per se, that is just computer program, cannot be patented in India. It can be patented in US and other countries, but in India we don't allow it. So how can you protect a patent, protect a computer program? You can copyright it. So again, for the Copyright Act provides for measures or provide for instances where you can publish a paper, publish a journal, and then you can copyright it later. Even means copyright is kind of a natural act, natural protection. You don't need to file for a different copyright. If you are publishing a paper and you are disclosing your computer program in that paper, then you don't need to get a separate. You don't need to apply for a separate copyright, because first disclosure of that computer program, and it is the date of the first disclosure of computer program is written on the paper or journal itself. So from that date, it is copyrighted in your name. Anything that is disclosed in any journal or in any scientific conference paper is itself copyrighted.
So no need to apply for copyright again after the publication.
Yeah. Means it if that particular case goes to some legal court. So in that court you have to prove. Whether you were the first owner of that. So in case of publication, in case you have got it published in journal, you will be able to prove in the court that this on this date this was published by me. So the court will understand that this you are the actual owner, and you don't need to show them any copyright kind of certificate to the court. It's just about ownership.
So then after the publications, can I put it to other countries for patent?
Yeah, definitely. But in that case also, there is a section in our Patent Act, that is section 35 and section 39, which says that if you want to apply for a patent outside of India, first you have to take permission from Indian Patent Office. Then only when the Indian Patent Office gives you permission, you can go to other jurisdictions such as US and EP and then file it there.
In this case, only we check for that is application is related to defense or atomic energy or not.
Yeah.
If it is not related to atomic or defense, then we will apply. Then we give the permission.
Yeah, we just check whether it is it should not be related to defense purposes or atomic energy. Otherwise, the office will give you a permission. Okay, you go and apply to US or any other country you want to, and then you are free to apply it there.
Thank you.
So it was very short kind of a presentation in which we tried to accomplish all the things, all the basics of patent, how to file a patent, what is a patent, how to draft a patent, and all these things. So there may be many more doubts. If you have any doubts, you can ask us. We have some time left with question and answer session. I think there is no any doubt regarding that. Pankaj sir?
Sir, how can I check whether my product is patentable or not patentable?
If it that search, you have to search it.
How?
You have to search it and what invention you are providing. What is the solution to your invention? You have to search for that. If you get any citation you are getting, then it cannot be patented also.
Yeah.
If you are not getting it,
And
then
what will be the keyword checked?
that your what your invention you are disclosing, that is depends on the keywords of yours.
Okay.
Yeah, for example, we took this case.
Just like you have seen the sanitizer dispenser. I'm searching for sanitizer dispenser. If someone wants to file a patent on sanitizer dispenser that is touch free, or dispenser that is cannot be touched and automatically a person will go, dispenser sanitizer will be dispensed on his hand. What your invention is, that what then you can only search it.
Okay, so
one cannot decide instantly that my patent invention is patentable or not, but only through search you will able to know that this type of work is already done or not.
So there is one thing about patentability, and the second thing is about the inventive step. So Sanjeev told you about if you have done the whatever work you have done, whatever is the invention, is it novel and inventive? Is the work done for the first time, or somebody else has done the same work or similar kind of work previously? So for determining whether it is a new work, you have to search. You cannot tell just looking at the document whether it is a new kind of a product or new kind of a process. So you have to go search in the databases like Google Patents and all the free databases that were told during the presentation. So you can go on any of those free databases. You choose from the abstract and from your disclosure, from the description, what are the keywords in your patent application, and using those keywords, you go and search for the eligible or the similar kind of documents. Go and read those documents, read the abstracts of those documents, and see if your work matches their work. And if you see that that kind of a work has already been published, then definitely it will be an anticipation for your patent application, and it will be difficult for you to get a patent for that particular thing. And apart from it, patentability is an issue. So like in the previous question, I told that computer program per se is not patentable in India, even if it is an invention. So for ascertaining whether that particular invention, kind of an invention, even if it is new and inventive, is patentable in India, you have to go, and there are certain things that are not patentable. Apart from it, all these things, all the other things are patentable.
Okay, sir.
So, and one more thing I would like to add about the searches in the search. Yeah, Sanjeev told about the two basic kinds of search you can do. The first kind of search he demonstrated by taking an example. He used Boolean logic. Second kind of a search, he used Boolean logic, he used proximity, and he used wildcards, and also used keywords. The other kind of a search that you can use, or other kind of thing that you can use, is classification, that we have not been able to tell you. Classification is all patent applications are classified. There is a code like A, B, C, D, starting from A, B, C, D, E, F, G, H. H is for electricity.
Just like a library.
Yeah, just like a library, as the catalog, like cataloging of books in a library. Similarly, cataloging of all patent applications is done based on a classification system that is called IPC, that is International Patent Classification, or CPC. cooperative patent classification. So if you understand what is IPC, what is CPC, and you are able to classify your invention, it will be very easy for you to search for similar anticipating documents or similar prior art documents which are relevant to you.
The benefit of IPC and CPC is that suppose Japan has filed some application, they are using some just like a glass, they are writing something else. In India, we are writing glass, but the classification of that application that will be classified by Japan Patent Office, they will do the classification appropriately that it is related to this type of invention, and classification will be done accordingly. If you search by classification, then that document will be also shown to us that we are not searching glass also. But what they have written, what they have classified by classification, we will get that document also. That is a very complex thing for others to understand. In patent office, we generally use CPC and IPC.
For example, it was told to you during the starting first part of that we don't in anticipation in patent literature. It was shown that in the first slide itself. You can see it here. Okay, so in it is written here that plagiarism. The third point is plagiarism check. In patent application, there is no plagiarism check. You can copy the material from anywhere. While in NPL, in non-patent literature, NPL, there is a plagiarism check. You can't copy the words. Why is it so? In patents, we see, means for example, this is a glass. Now, you can use this word glass. You can use a word tumbler. You can use a utensil for pouring water or a utensil for keeping water. So there may be n number of terms or n number of phrases by which you can determine this object. So in patents, you have to use synonyms of the same term for searching. So this is one of the important cues or clues we can give you that if you are searching, you should use synonyms of the thing or keywords that are using. For example, antenna or a particular kind of a thing, then you have to find out all the alternates or all the other names of the same thing, synonyms, and then use all those synonyms with the syntaxes that we have told you. For example, uh, there were Boolean operators like or. So sanitizer or disinfectant. So in a because sanitizer and disinfectant are one and the same thing or similar things. So either there should be a word sanitizer or there can be a word disinfectant. Similarly, in your applications also you have to keep this in mind. I hope this clarifies. Any more questions?
Can we have
Hello.
so that in future if we have any queries, then we can contact you?
Yeah, my email ID is there last. My email ID is there. You can note it and you can mail me also. Any other questions?
So one question I asked. Sir, I want to ask if I'm
Your voice is
doing
not
an
audible.
invention in India,
Audible.
I'll always file a patent.
Sorry, Runa, your voice is not audible. Please repeat it.
Hello.
Yeah.
Hello. Hello. Can you hear? Hello.
Yes, yes,
Hello.
please. Yeah, you
So
are
can you hear
audible.
now?
Yes.
So I want to ask that if I'm doing an invention in India, it is always that I'll file it from India or say, what is the use I from other country?
You are saying, as far as I could hear it, you are asking, you have filed something in India. What is the benefit of filing it in other countries? Is it so?
No, sir, I'm saying if I'm doing an invention in India, I will file it from India, not from other
Yes.
country, right? What is the use of filing it from other country?
What is the benefit of filing initially in other countries?
It
I
from
don't get your question because your
yeah,
voice is
no,
breaking.
why
You
will
can,
I file it from other
You
country?
can put your question in the chat box.
yeah, you
Chat
can
box.
put your question in the chat
Will I
box.
file it from
Your voice is breaking. You're not audible. So please, if you have that question, you can put it in the chat box so that everyone can see that question. I would say,
Or you can mail to the skmoto.ipo. We will clarify and give you the reply.
yeah. what is the use of filing from other country? Okay, so no, Runa, there is no as such no benefit of file. If we are Indian citizens, there is no benefit for us to go to other country and file that application in other country. If the invention is from India, if the inventor is from India, there is no benefit of going to other country and filing it.
Yes, sir.
Okay, there is no benefit. First thing you need to understand about patent is
Okay.
a territorial right. What is territorial right? If you are filing for a protection in India, you will get protection only in India. So if you have a technology, you got a patent in India. Now you have the right of that patent only in India. If someone in Nepal goes and pirates your product, there is a piracy of that product in Nepal. You can't do anything.
Yeah.
The companies which invest heavily in R&D, what they do is they protect, they take the patent, they go all over the world and protect it all over the world in US, in EP, in Korea, in Japan and so on. जहाँ पे भी उनको मार्केट प्लेस मिलेगा वहां पे उसको प्रोटेक्शन उसको सीक करते हैं. So for academicians like you and all other students and teachers in universities, there is no logic of protecting going outside India and protecting it first there and then coming to India. So better you protect it here, and if you think that it can be commercialized later on, then you can think about protecting in US and EP, where you can commercialize and earn a lot of profit from your patent.
Thank you, sir.
So